Good morning or good evening, everyone, depending on where you are in the world. My name is Steve Brunn. I lead private sector engagement at Winrock. I'm based in Wisconsin in the US. Just a brief note on our agenda today. So I'll be providing some brief background on the panel, the subject matter. Then each of our panelists will be introducing themselves briefly and have some introductory remarks. And then we'll move into a discussion for most of the time on the call, which will then be followed by Q&A for approximately 15 minutes. So as Hermes said, please enter your questions into the chat, and then I'll be moderating that Q&A at the end of the session. So the subject that we're discussing today is the EU Directive on Corporate Sustainability. And that directive outlines ESG requirements, due diligence requirements, reporting for large companies operating in Europe. So they define large companies as meeting 2 of 3 criteria, and those criteria are greater than 250 employees, greater than 40 million euros in revenue or turnover, and greater than 200 million, one more time, greater than 20 million euros in assets. So they have to meet 2 of those 3 criteria. The requirements themselves include reporting on risks and impacts to people, the environment, and also associated financial risks to those environmental and social impacts. Requires ESG target setting and requires due diligence of the company's own operations and its supply chain. It also requires that companies have clear roles and responsibilities for ESG. And that those are maintained over time. So as we were preparing for today's panel, we realized that we really needed to set the context first, because we realize those who are attending today may have varying levels of degrees of understanding of this legislation and also the context for the legislation. So the opening remarks from the panelists will cover those topics, including why is this legislation necessary? What is the role in business in addressing, in this context of the call today, human rights? What is the historical context for this legislation? What's the status of the legislation within the EU bureaucracy? And how does this legislation build on previous legislation? So with that, I'll introduce our first speaker, Matt, who will be talking about the role of business in human rights and why this legislation is necessary.
Thank you, Stephen, for that. My name is Matt Friedman. I'm the CEO of an organization called the Mekong Club. We work with the private sector in a positive, supportive way to address the issue of human rights, modern slavery, to help them to understand the issue, what they need to do and how they need to do it. I'm just going to say a couple of opening remarks about kind of the reason why the private sector is involved in this particular sector. As we've all seen, the number of modern slaves has gone from 40 to 50 million, partly because of COVID and various other factors that are happening around the world. Within that number, 27 million of them are associated with forced labor. Now, the reason why the private sector is involved is 60% of the 27 million would be associated with something to do with supply chains. Supply chains are where we find the private sector, and as a result of that, there's kind of a justification for their involvement. Another thing is the profits generated from modern slavery are estimated to be 150 billion US dollars a year, second only to drug trafficking. And when it comes to the impact that the world is having in terms of being able to address this issue, less than 1% of the victims around the world are being helped and saved and rescued from governments, United Nations, NGOs, corporate sector combined. So when regulators and governments came to realize that there was this touch point with the private sector through supply chains, and that they needed to bring another kind of group of organizations in to be a part of the fight to respond to this, we saw some changes taking place over time related to the private sector. The first change is changes related to regulations. The California Transparency and Supply Chain Act was put in place in 2012, followed by the UK Modern Slavery Act, the French Act, the Australian Act, the impending German and Canadian Act. And all of those acts basically kind of have as a mandate that you as a big company have to say what you're doing to address modern slavery. We'll get into the details of that a little bit later. We're seeing more emphasis on lawsuits against major companies. Some Major retailers are being sued because they get seafood from different locations, chocolate companies and so forth. This creates a reputational risk and motivates companies to try to figure out what they need to do in order to prevent that from happening. We're seeing a significant increase in media coverage associated with this, almost a doubling every year for the past 5 years. ESG, which is the private sector version of the SDGs, are now emphasis the relevance and the importance of modern slavery. So ESGs are voluntary indicators used by big companies. Investors then look at whether or not companies are doing right by the environment, by social issues, by governance. And as a result of this process, more investments goes into companies that take this seriously. In order to address the S in ESG, you have to know about modern slavery. So all of these trends are pretty much moving us in a direction whereby the private sector has an expectation of not only understanding what it is that they need to do in order to address the issue, they also are expected to do things. Now, the expectation that kind of goes along with a lot of the legislation is that they have to raise awareness within the organization from C-suite all the way down through the brand into the subcontractors and sub-subcontractors. There has to be a focal person within the organization or a team that focuses on this. Many companies don't have that type of approach. Policies, procedures, codes of conduct are being updated and improved in order to accommodate making zero tolerance the statement that a company makes and having that cascade down all the way into the supply chain. Extensive training, both within the company as well as the factories, the sub-factories, the sub-sub-factories, to allow for workers to know what's going on. Risk assessments to determine the relative risk within locations to see whether or not a factory that a brand is working with, whether or not there's vulnerabilities that are kind of built into that, for which more due diligence would be needed in order to ensure that a brand doesn't find themselves in a situation. Much more scrutiny related to auditing, to get deeper down into supply chains to be able to address this, grievance mechanisms that allow workers to give feedback, and remediation. The point is that in this day and age, the private sector has been drawn into the response to address modern slavery. Legislation is very much part of that. And with that, I'll just stop my comments. Thank you very much.
Thank you, Matt. Marina Colby is up next, and although Matt provided some of the historical context, Marina will provide some additional detail on what's led us up to this point.
Wonderful. Thank you, Steve. Thank you, Matt. Thank you, everyone, for being here today. My name is Marina Colby, and I serve as the Senior Labor Advisor at the U.S. Agency for International Development. And looking back, that's a little bit of what I'm going to do now, is really look back at the sort of origin story behind the legislation, the supply chain due diligence legislation that Matt was laying out for all of us. And I have to say, I've been around for a while. So I'm looking back to the year 2020 in the United States, when the Trafficking Victims Protection Act, a piece of federal legislation, was passed. It was actually passed as part of our Violence Against Women Act. And I think that's important, noting that at the beginning of the supply chain due diligence story, at least in this modern era in the United States, it was the anti-trafficking movement. It was the women's rights movement. It was the activists that really pushed our government to draft this law, and they definitely helped to shape it. And in 2020, it's really interesting to prepare for this talk. I went back and I looked at that original law, and I really recommend people who are engaged in this movement and want to see what some of the findings were in relation to human trafficking around the world. You can find it in the findings or the beginning of this law that lays out 24 reasons why the U.S. should have a national law on human trafficking. And one of them sticks out to me, and that is a reference to our Declaration of Independence. that recognizes the inherent dignity and worth of all people. And that's really at the center of our work, all of our work in this movement today. And Matt also mentioned California Supply Chain Transparency Law, which was being drafted in around 2010, implemented in 2012. And just to spend a moment with the importance of that law. California, as many of you may know, is a state in the United States, but its impact was felt around the world, largely because California is, I believe, competing now with Germany to be the 4th largest economy in the world. So what happens in California can have rippling effects around the world. And then if you really look at that law, if you go back to it, and you can easily find it online and read it and look at the elements, it doesn't mandate that businesses implement new measures to ensure that their product supply chains are free from forced labor or human trafficking. It really started out as a disclosure law for consumers to have more information so they can determine whether or not the goods or services that they're consuming have forced labor or human trafficking built within it. So it's essentially a disclosure law. So a company is then, and not just any company, this is also important to point out. So the law is looking at larger companies and asking them to do some internal investigation of their own business operations, and then to develop a policy on how their business is identifying risks of human trafficking and forced labor, and then to develop a policy, and then to publish that policy publicly on a website, on their website. And compliance with the law back then in 2010, it was hard to get a lot of accountability or teeth in the law in those years. So if you didn't have a policy, you didn't have a verification system on the risks of human trafficking or forced labor, and you weren't auditing your supply chains, you could say that and you were in compliance with that law. But it did set, I would say, a precedent for countries to start looking at this law and taking it steps further. And today, looking at today in 2022, there are a range of countries that have now developed supply chain due diligence laws for themselves. And we're looking at and discussing a few of those countries today. And they range from, there's a Dutch law on child labor due diligence, laws in Germany now, and the EU will be getting into more detail. But long story short, what I wanted to say about the California Supply Chain Transparency Act is that it set in motion other national level legislation with progressive improvements over time. So we're seeing, in addition to social due diligence and risk assessments and compliance, the addition of environmental due diligence. So social and environmental, that's a progression. And then we're also seeing in some of these emerging laws, significant administrative and criminal penalties. So back in 2010, this, I can say, as I know the drafters of this law, that this was the sort of progression that they envisioned. And so now it's coming to fruition, and I'm really pleased to be on this panel with some true experts who are really at the front lines of implementing and ensuring that these supply chain due diligence laws are well respected and implemented. Thank you. Back to you, Steve.
Thank you, Marina. Okay, so now that brings us to the current day and the status of the EU directive within the EU bureaucracy and kind of the path forward at a country level. So now we'll turn to Anna Moore from Elevate to introduce herself and to provide a bit more context on that subject.
Thank you, Steve, and thank you to Matt and Marina for the wonderful context setting. I hope I can do justice with the current day explanation. Thank you very much, everybody, for joining us as well. My name is Anna Moore, and I work for Elevate Global. I am a senior consultant, and essentially what we do at Elevate is we advise corporate companies in social compliance, human rights, and environmental due diligence. So over the past few years, as we've just heard, more and more countries are adopting mandatory human rights due diligence. These laws are affecting both domestic and foreign business, the way that they operate in countries, the way that their supply chains work. And although for many decades, businesses have been encouraged to really take responsibility for their supply chains, there is an abundance of research that shows us that the voluntary soft law approach is just not having the kind of impact that was really hoped to be reached to ensure responsible business practices. So as a result, all these necessary changes of legislation that we've heard Matt and Marina explain to us there have led us to a point where across the world, if you really map it, you can see that there are legislation, hard law, there are also softer guidelines in different parts of the world as well. And although there are systemic societal issues that lead people to be trapped in forced labor, issues such as poverty, discrimination, social exclusion, and weak rule of law, in whatever context that may be in, there is acknowledgement widely that business models and operational strategies for business can spur the problem of forced labor and human trafficking at rates that we're seeing now, and Matt touched on those numbers earlier. So without getting too bogged down in the technicalities of what the EU directive is coming out of, I will just provide an overview of the difference between the EU Commission and the EU Council. So essentially, the very simplistic version of this is that the EU Commission proposes the new laws. So it gives those new laws a breath of fresh air, if you like. And then the European Council chooses whether or not to adopt them. So once the laws have been adopted across various EU governing bodies, it is then mandatory for the EU member countries to implement those laws. And then the role of the EU Commission thereafter is to ensure that those laws are properly applied in each of those member states. So now that we have the terms of the different, where the directive is coming out of, let's talk about where we are now. So in terms of the status of the EU's mandatory corporate sustainability reporting directive, essentially in February 2022, the EU Commission published a very long-awaited proposal for the directive on corporate sustainability due diligence. Lots of NGOs and other bodies had been really campaigning for this to happen for a very long time. But the last few weeks, just before this webinar is airing to you, there's been a lot of movement. And so the European Council, which is that EU body that gives the go-ahead to adopt these new laws, has just last week given its final approval for the mandatory legislation, which means that it's likely to be enacted into law sometime in the spring of 2023. So for companies, That means that they will be required to evidence the bi-directional relationship between their business and their operations model against the required sustainability objectives, be it in relation to the environment or, as we're here to talk about today, human rights. This has been a long-awaited proposal and a long-awaited adoption. So, of course, there are controversial elements to this. And where some of the controversy lies at this very moment in time is that the adopted legislation largely left out financial institutions and banks from the reporting requirements of the directive. So according to the EU, the idea of this is that the reporting standards would allow investors to make informed choices because they would better understand where companies are in terms of their responsible business practices, and therefore financial institutions could invest wisely in companies who were reporting that their standards were high and evidencing that. Now, many of the critics, some of whom have been campaigning for this law to be enacted since 2017 and some beyond that, some of them argue that the omission of financial institution leaves the rest of this decade and more open for continued investment in fossil fuels. So it's not cut and dry as to whether or not this is going to have the change it will in terms of the environmental impact, and in terms of the human rights impact, that's also not clear yet, as we haven't seen the outcomes of this law. But despite the ambiguity, there is an urgent need for such law, and many people agree on that. Because, as I mentioned earlier, decades of voluntary corporate efforts have failed to drive meaningful action to prevent forced labor in corporate supply chains. And so, as was mentioned, there are currently many millions of people in forced labor in the private sector at any given time. And so this involves people involved in the production, the manufacturing, the processing, and the transporting of goods exported to the EU, as well as products produced in the EU. And that's why this law really matters, because it will essentially start to really regulate those supply chains and try to make business practices more standardized and better equipped for what we will understand business in the 21st century to be.
Thank you, Anna. We'll now move on to our final panelist, Archana. And Archana is going to talk a little bit more about the directive itself, the key requirements of it that build on and progress from previous regulations. Archana?
Thank you, Steve. Thanks, everybody. And thanks to my fellow panelists as well for setting the scene so eloquently. I guess as an advocate in this space and as a practitioner, this law, these laws and this new space of focus on human rights due diligence, etc., is, for me, a reset that was much needed. We are emerging from a pandemic. We are seeing devastating impacts of climate change. And, all of this just to say that we really need to take a different way and a different approach to the way we look at things. And what started essentially as a movement around creating transparency, awareness raising through the California Transparency Act and various other similar pieces of legislation is now morphing into something with a lot more teeth. As Marina described it very eloquently, it's a sort of progressive improvement with the different iterations of the law. So I think the tide really started to change with the French vigilance law, where there was an emphasis on providing a vigilance plan, which involved risk identification, but also a plan of how to manage the risk. One of the interesting trends we also start to see at that point onwards is the movement from transparency to transparency and accountability, with the introduction of mechanisms such as civil law mechanisms that would allow somebody within the extended supply chain of a French parent company to bring a case in or file a claim in France against the parent company for a violation that happened elsewhere in its extended supply chain. We see this trend really picked up and reinforced through the European due diligence legislation as well. But what was perhaps more interesting and exciting for me, and please forgive me, I'm a lawyer, these details really excite me, is that in 2011, the UN guiding principles were endorsed and adopted. The UN guiding principles on business and human rights essentially set out the operational framework of how business should think and act in relationship to its impact on human rights. So this is in relation to any adverse effect that business activity has on human rights. And within the UN guiding principles, we really start to see the beginnings of transparency, accountability, the idea that risk needs to be identified, it needs to be managed, it needs to be mitigated. There needs to be a great deal of stakeholder engagement. Rights holders are central to this activity. And there is this concept of a value chain, not a supply chain. What has been interesting with the new iterations of the due diligence laws, and in particular the European law, is this sort of focus again on the value chain, not the supply chain. The distinction is the value chain really goes into upstream, downstream, and the company's own operations as well. And it's a much, much broader idea than just focusing on the supply chain and direct business relationships. We also start to see a movement away from just looking at issues like modern slavery, child labor, or forced labor into a much broader idea of human rights, the impact on human rights. And that's really important because actually, if you look at forced labor or you look at human trafficking, it is a violation of a series of rights. And it's a combination of these that is packaged up as an offense known as human trafficking or as an offense known as forced labor. But underlying these, you see cross-cutting issues such as discrimination and various others. So the recognition and the broadening out to a narrative around human rights is very important because that essentially gets to a much more systemic approach than just focusing on issues of modern slavery and just focusing around transparency. Around the accountability piece, one of the things that really emerges is the emphasis on these civil law mechanisms and the need to be able to hold companies accountable for harm that is done in other jurisdictions. It's almost shrinking the proximity and basically ensuring that there is a lot more accountability through the way the supply chain operates. The emphasis in the law around grievance and systems of remediation is also very key. And the focus on industry-wide standards, in particular, for example, we see this in the German law, really drives to the attempt to really raise standards, not just in a company's operations, but rather on an industry level. Because very often the problems we see at one company level are not homogeneous, are not just at that company level. They're actually problems that are shared across the industry. And what has been really interesting is the emphasis also on human rights due diligence reporting and communication. It's not enough to say that you are doing lots of good things. It's important to report on the impact and the intended and unintended consequences of these. So we really start to see a shift from transparency to accountability and from a lot more expectations of the role of the state. Because as we talk about the private sector, there is an emphasis or there is a tendency to really forget the role that the state is required to play in respecting, protecting, and remedying the rights of individuals. And I think legislation of this nature really reminds all of us of the role that the states have to play. I think one of the other important developments really is the convergence of human rights and environmental issues. Very recently, the right to a clean, healthy, and sustainable environment became a human right. It brings together a lot closer the E and the S elements in the ESG movement. I think we have for many years worked in silo, but actually the overlapping nature of these issues cannot be disputed at all. And I think we start to see in these laws a requirement that it's not good enough for you to just look at how you manage your human rights, but actually environmental issues and various other issues also need to be looked at from this lens. As somebody whose work is very much focused on access to remedy and remediation, it has been particularly exciting for me to think about and reflect on the opportunities that this new law presents in relation to access to remedy. And I think it would be remiss to talk about the human rights due diligence law and not to mention the complementary trade sanction law that is also sort of, bubbling away on the side. So very much like US Customs and Border Protection have the US Tariff Act, which allows the United States Customs and Border Protection to basically hit with the WRO goods that are coming into the United States that are tainted by slavery, forced labor, child labor, or human trafficking. In a very similar manner, the EU are also considering a regime that will do something similar, and this is set to act in tandem with the sustainability and due diligence directive. I think where there is room and opportunity to do more in the next iterations of the law and in the advocacy that surrounds this is to really look at the centrality of rights holders. And I think the law doesn't do that enough. And there needs to be a lot more emphasis on it. And I'll just leave it here by saying that a lot of the laws that are emerging around human rights due diligence, in particular this European law, really hail from the UN guiding principles. It's an attempt to put into hard law the teachings of the UN guiding principles that are actually considered to be soft law. And in essence, what we are starting to see now, I see that a lot in the work that I do on a daily basis, is the private sector working hard at trying to align their policies and processes in line with the UN guiding principles, because that is the highest standard, and that is the standard that is being picked up and replicated across these different versions of the law. Thank you. I'll leave it there for now.
Thank you, Archana, for sharing some of how the EU directive is a progression, but also some of the gaps that still exist. For the remainder of the discussion session, which will last until about 10 after the hour, we're recognizing that the audience today is quite diverse. And this specific legislation obviously applies to the private sector. We recognize that not all of you are from the private sector. So what we want to do is progress this discussion from an assessment of how this legislation impacts business generally, what are some of the actions that they're going to have to take, to then what are some of the very specific applications within Asia, the focus of this event, and then how do the other stakeholders, how do the other organizations that work with the private sector or have some type of relationship with the private sector, how can you effectively work with the private sector to help them and to help rights holders meet the expectations of this legislation? So with that, we'll start off at a general high-level view of what are the implications of this for business. And Matt, you started to talk about this in your response, but maybe just providing a couple more specific examples of some of the actions that that corporations are likely going to have to take as a result of this legislation.
Well, one of the big things that I see when I'm having contact with private sector is the extent to which they need basic awareness on this particular topic. Those of us who are on here have been focusing on human rights, modern slavery, human trafficking, all of those things for a long time. When you look at a corporation, they are focusing on marketing and pricing and all kinds of other factors that, for the most part, is very specific to their business. And so what we're seeing is that initially a lot of the corporations kind of come to the table feeling like, I wish we didn't have to do this. But then when it's approved and agreed to, then they start saying, okay, what is it that we need to do in order to address this? I think kind of the one piece that I'd like to say that is often missing with this type of legislation is the requirement by the government themselves to help the private sector through this transition process, to actually get up to speed on what it is that they need to know, what tools are available, who is out there that's working on this that can provide advice and guidance. Because I think once the private sector kind of accepts the fact that this is a requirement and it has to be done, they're willing and able to do it, but many of them struggle with, how do I get started? You know, how does this translate in terms of what is the amount of work that I have to do that meets a particular minimum? You know, what is it that has to be done in order for me to ensure that I'm in compliance? And oftentimes I feel like the corporate sector doesn't really know how to answer that question. And in fact, much of the work that I do is working with corporations to help raise that awareness, look at their policies and procedures, identify what it is that is perhaps a gap that needs to be addressed, but there needs to be a lot more of that. And I think if that existed, you'd have a much better kind of sense of accountability, as Archana was saying, beyond transparency, to allow for companies to not only get things on a checklist, but to actually demonstrate that what they're doing is potentially going to protect workers in the human rights realm.
Thank you, Matt. One other question that occurred to me, which we hadn't really discussed previously to the panel, but feel free to intersperse an answer to this question in your remarks if it's relevant. But one of the things I was thinking of in the introductory remarks is, are there unintended consequences of this legislation? And one of the things that potentially occurs to me is because of the additional requirements, our country is potentially going to be less likely to interact in value chains that are in countries that are potentially higher risk from a human rights perspective. Could that cause them to potentially pull back and not source from or operate in those countries? So just one thought that you can consider as you're making remarks as well. I want to turn to Anna now. Anna, obviously working for Elevate, an organization that works directly with corporates. I'm curious if you have some thoughts on general implications of the directive for business activity.
Yeah, I think in terms of the EU directive for business activity, I think one of the things that sort of gets missed when we're talking about this legislation is that the EU is the world's largest single market. And so an EU-wide law would likely have implications across many different value chains and supply chains. And it's important because many European countries, I think Archana touched on this, are they're considering business human rights, or they're already enacting those laws, or they're in the process of reviewing those laws. Some have already introduced them, others have not, but are thinking about it. And so having this EU directive really will set the standards and expectations of converting that voluntary guidance that, as was mentioned, is really based around those UNGPs to become a bit clearer. And so some of the implications of this for business are, of course, parts of the issues that have been touched upon in terms of corporate practice. And so I think when we're really thinking about what corporates can do, what the implications will be, one of the things that I often say to my clients is that there has been due diligence in corporate supply chains for a long time. It's just that that due diligence is focused on finance and business risk. And so one of the things to really consider here is that this procedure, this instrument of due diligence has a very long history in the corporate sector in terms of corporate transactions. It's just that more recently, what we're seeing is that due diligence is applied to those non-financial areas of business. So in essence, the legislations and the guidance is being applied to a world that seems unfamiliar to a lot of businesses, but it is the world that businesses live in and operate in. So although it's unfamiliar territory, to really look into the impacts and either intended or unintended consequences of business actions, it's important to remember that this familiar commercial interpretation of due diligence is already there. It's just that we are moving it into, we're taking, and this is one of the points that the late great John Ruggie mentioned, was that we're just moving that standard of due diligence, that way of corporate operation, we're just moving it to a different theme. It is not that due diligence is new. It is that taking care of our environment and taking care of our people and our planet with our business operations. That's the new bit. And so although for a lot of companies it can feel quite scary, because they may feel that they're being asked to do something they've not done before, it's the theme that has changed. And so what can you do when you're not an expert in a particular theme? Get those experts in, because they're the people that will help you understand what are the environmental implications, what are the human rights implications of your business. And so although it can seem like the legislation is very, very complicated to enact, especially if you're a huge global conglomerate, it's really about starting with those salient human rights issues. And if you don't know what they are, find out by using either external companies to help you find out through assessment, through investigation, all of these things that are wonderfully listed in the UNGPs as to, you know, the ways that we ensure that access to remedy is met. And so it's important that businesses meet their responsibilities, but I think looking at it as something that's completely new is maybe not the most favorable way to look at it in terms of how you take it to your boardrooms to get this these policies and practices embedded into your company's ways of working. So it's a new theme, but it's not a new way of working. The due diligence has always been there.
Stephen, can I just add something just very quickly? Unintended consequences tends to look at negative. In some ways, I think there's a positive element to this, and that is that, you know, a lot of companies struggle with the S in ESG because they don't really know how to address it. This is going to force everybody to really focus on the human rights element of ESG in a way that I've actually had companies say, well, now to a certain extent, because we have to do this under legislation, it's going to help us in the long run to be able to address these indicators over time.
Certainly, and I think those of us who have worked in corporations, you know, when we've tried to take specific actions that are not necessarily required by law, we've met some resistance to that. And I think you know, having legislation like this makes it easier for those internal advocates within corporations to actually see their actions come to, or their ideas and the things that they know will actually make improvements within value chains. It will make it easier for those things to actually happen within corporations. So great point, Matt. In the interest of time, I think I want to progress to some more specifics in terms of the practicalities of this in Asia, and some specific examples of how this is going to apply. So certainly, Marina and Archana, as you're replying to that theme, feel free to provide more general comments or comments on unintended consequences. But I'd love to get into a discussion of some of the direct practicalities, maybe even specific countries, specific supply chains in Asia. So Marina, could you start? Thank you.
Yeah, that's great. Thank you. Thank you so much. And I want to bring this down, you know, from USAID to a development perspective, and what's really happening, you know, in countries at the source, you know, sort of the bottom of these supply chains or value chains. Thank you. And noting how we're also moving away from these point in time audits of suppliers, you know, not the whole solution to these issues, but really getting down to worker engagement, right? Worker voice at the table. And knowing as a long time labor rights promoter and now a senior labor advisor at USAID, that when workers are at the table, We're going to see better working conditions. We're going to see better wages. We're going to see health and safety issues more respected. We're going to see sort of like no space for child labor or forced labor. So that's really important. What's happening at the source, and being engaged there. And one example I'll bring up from USAID is we once had an initiative called Supply Unchained. And this was an initiative, it was like a time-bound initiative, and we were testing out some of these ideas that we're talking about today in terms of looking down that supply chain, really at the source, like in communities. And I trust Steve remembers at the time because we partnered with Target, the Target Corporation, and an on-the-ground NGO called Goodweave, working in the carpet sector in Nepal and India. And this particular pilot was in India. And so what the plan was and what we did do, because we had this partnership with Target, and they opened up their supply chain. They like really wanted to see all the way down for the first time. And USA, we were there on the ground, with our mission in India, with Goodweave, the NGO, and really going, assessing the working conditions, the wages at these carpet factories in India that are in Target supply chain, getting real-time data from the source to share with Target's responsible sourcing team, so they could know the conditions, the conditions of how these carpets are being made. And that's, to me, that was a really a fruitful public-private partnership. And then once you become more open and open-minded to really look where the challenges are, with open eyes, open ears, hearing from the workers themselves, engaging with them, bringing them to the table, you're going to have solutions emerge that are going to de-risk that supply chain, that value chain. And so I really want to emphasize that as a very good practice. And also to go broader, so these, Anna mentioned like there are sources. So also our partner agency, the Department of Labor, has a list of goods that they publish every 2 years. And that list of goods, as many of you may know, it'll name a country and a product. So India is on that list of goods, and with carpets produced with child labor or forced labor. And so there's awareness there, right? We know this. And so those are opportunities, if you are a corporate actor, you do work in this sector, you have information now. And then you can look for partners and suppliers and have supplier partnerships, which are also key to really engage with workers. And where there are other good models that engage with workers, like the coalition of Immokalee workers in the US and their worker management councils and the Fair Food Program, or over to the ILO Better Work project that works in garment factories around the world with worker management councils. So their workers are at the table. And I just really want to emphasize that point while I have the time. Thank you.
Thank you, Marina, for that historical flashback as well. One of my experiences at Target, that was certainly very influential in kind of deciding some of the work that I want to do further on in my career. But it was also a realization, and something that I said at the time. There's this term "ignorance is bliss," which is somewhat said tongue in cheek, but ignorance is really dangerous. Not just dangerous for the corporation and not knowing what's happening in its supply chain or value chain, but also obviously dangerous for the people in it. And the more that we can move away from the idea that we're going to turn a blind eye to what's happening in these value chains, the better off that we'll be as corporations, as society, and obviously for the people in those value chains. So, and this legislation obviously is a forcing mechanism to get us to that point. Turn to Archana now. Oh, Archana, yeah, go ahead.
Yeah, no, I was just going to say that was a great segue to make the point I wanted to make, which is basically this, that companies really need to move from being guided by compliance. Let's just tick the box and say we've done it because we're required to do it. What we're seeing in the new iteration of the laws is that there is a requirement to really go beyond that. There is a requirement to be guided by the impact that your activities are having on human rights, not by the impact that human rights has on your activities. So this needs to be a step beyond just doing risk management. Let me protect myself from those people that might want to sue me for something that happened to them, rather than looking at it from the rights holders' perspective and managing the damage that you could potentially do to them. And I think that's really important because they're two completely different ways of looking at things. And I really believe that in order to future-proof, yourself as a business going forwards, given the regulatory climate or the sanctions regimes that are coming up, that you really need to be thinking about that. I think the recent WRO action in Malaysia has really shown how much that can really expedite the human rights issue into the boardroom in the way that nothing else ever did before. And that has prompted companies to really, senior management, to really rethink about what it is and where it is that risk comes from. Who are these affected rights holders? And how do they need to be considered in the grand scheme of things? I think the importance, I'd like to really echo a point Marina made earlier around the need for social dialogue and engagement. We talk about workers having a seat at the table, but frankly, in so many of the countries where we work, workers aren't even able to be part of a trade union. And therefore, these are some fundamental liabilities and breakdowns in the national systems that create a tremendous gap between international standards and national standards. And one of the big difficulties that businesses with global supply chains have to navigate is how do we close that gap? And how do we make sure that our risk identification systems are picking up on where these gaps are and are finding ways to mitigate and prevent damage from occurring in this respect. A very interesting consequence of these laws coming into force is we are seeing a lot of calls from small and medium-sized enterprises in Southeast Asia, basically saying we're being hung out to dry here. We are being made to sign declarations. Our contracts with buyers are changing because the buyers want warranties and indemnities from us protecting them from potential liability. How do we manage this? We can keep giving declarations, but they aren't really worth much because we don't have the resources as SMEs to put in place a state-of-the-art grievance system or a state-of-the-art human rights due diligence system. What do we do? Where do we get this support from? And I think one of the very interesting ideas that is behind the human rights due diligence legislation really is that of shared responsibility. It's no longer a company in Southeast Asia who I sourced from was exploiting people. It's no longer that. The exploitation happens in the supply chain, in the value chain, period. Whether you're the parent at one end, you're a buyer, or whether you're the small supplier or the subcontractor, the responsibility is now being shared. And therefore, in a similar way, just as suppliers in sourcing countries are being asked to take responsibility for what's happening on their premises, in a similar manner, buyers are now being asked to take responsibility for how their purchasing practices are driving suppliers to behave in this manner. The responsibility has to be shared, and similarly, we need to see an investment from buyer communities and actors further up the supply chain into sourcing countries. Otherwise, we're not likely to see much change. And I think one of the other things that we are likely to see, which is also emerging, is more engagement between businesses, the business community, and states. Because unless states create an enabling environment where, for example, workers are free to associate, where there is an open discussion around labor shortages, around migration issues, we are unlikely to really see change happen at a systemic level. These are all things that, I think will happen. As for the Asian reaction, I mean, we already see some governments in the region, Japan, for example, reacting very quickly to the changes in Europe and in the United States, and putting in place guidelines around, which is essentially a copy and paste of the UN guiding principles. And we are starting to see discussions emerge in different countries like Thailand and Malaysia around the Business and Human Rights Action Plan, which is a national action plan and which has a role foreseen, not just for the private sector, but for the state and for other actors such as civil society, etc. So I think, we are set for some very exciting changes. And I would certainly like Marina to echo the message that we must keep affected rights holders at the center of all of these efforts.
Thank you, Rachana. And I think we're kind of naturally progressing into the last question, which is, how do we as civil society organizations, as governments, either national governments or jurisdictional governments, as development organizations or projects, how do we work with the private sector to address these specific challenges? And also, what's going to, from the government perspective, what's going to happen legislatively within some of these countries? So Anna, I want to go to you on a couple of points, both on what might be happening legislatively in Asia, but then also in representing Elevate, an organization, going back to Archana's point, that kind of the mindset of perhaps moving away from compliance. One of the things that I know Elevate does well is show companies how their interests can align with improved human rights, improved working conditions, et cetera. So if you could share some thoughts on that. Thank you.
Thanks, Steve. Yeah, I think, the point that Archana raised specifically about WROs and companies in Malaysia, we at Elevate, I specifically have been working very much with companies who have been sanctioned in that way, and the turnaround is very fast. It can be really a couple of years from the start of that WRO process to having reimbursed workers for fees, having grievance mechanisms in place in supplier and factories. So it is possible to turn things around quite quickly for businesses, and we see that a lot. I'll come back to that in a moment, but I will just touch on something else that Archana mentioned, which was that there are a number of governments in the Asia Pacific that have developed or are in the process of developing the national action plans that Archana mentioned, and it's specifically national action plans on business and human rights. So Thailand in 2019 became the first country in the Asia Pacific to publish a standalone NAP on business and human rights. We saw Japan in 2020. We've also seen other countries start to include chapters on human rights within their national action plan more generally. So South Korea is one of those. And then we also see India, Indonesia, Malaysia, Mongolia, Pakistan, all in the process now of developing national action plans on business and human rights. And so it's really moving in the region in a direction that is very much in line with the scene setting that's coming from the US and then the European Union as well. And we've seen the Australian government enacted a Modern Slavery Act back in 2018, but I believe it was just 2 weeks ago that Modern Slavery Act is being updated. And so there's a new customs bill amendment that's being discussed in the Senate. And then, of course, we've got things going on in India with the National Guidelines on Responsible Business Conduct. And even in terms of investment, the Thai Securities and Exchange Commission has announced that all companies that request approval to do business will be required to disclose information on their respect of business and human rights in line with the UNGPs. So, you know, it's a fallacy to think that these sorts of guidelines, legislative movements, whether they're soft law or hard law, are just coming from the EU or the US. This is absolutely not the case, and we're seeing this a lot. And to touch on what Archana was mentioning and what you mentioned there, Steve, it's what we're seeing a lot more is that as corporate entities really start to get involved in the human rights piece, there are many byproducts of this that are unexpected. So parent companies, buyers who've previously had very tense and difficult relationships with their suppliers, because essentially the only contact has really been, we need this at a tighter deadline than was originally agreed, and we need it for a cheaper price. That's been a lot of the business model that we've been seeing. Now, as we work with companies, I'm working with some US companies at the moment who've come together. They're in the same sector, but they are competitors usually, yet in this space they are together and collaborating to set up grievance mechanisms in suppliers, factories that they share. So you might have high-end and low-end brands who are sharing these enormous factories in parts of Asia, and they're coming together to make sure the workers, thousands of workers in some cases in one place, have access to grievances. And one of the byproducts of setting that up and the work that is involved in setting that up is that supplier and buyer relations improve. So people are able to have more effective business relationships, because it's not just demanding emails about particular price changes or time changes. It's thinking really holistically about what the business is and how some of the business models in fact exacerbate some of the negative conditions in these factories, and allowing those conversations to come to the table and thrive. So, you know, it's in remedying the access for standards of living that the workers are owed, and ensuring that they are not being trapped in bonded labor or forced labor. In ensuring that, you also see less tension in buyer and suppliers, not in all cases, but in many of them. So it's almost like a win-win. The more you talk about the human rights and the environmental impacts of your company with the very people who are conducting your operations to make your company work, the more positive impact you can have, and your business can still thrive. So this is what we're seeing, certainly at Elevate, and I know that my peers in other organizations are seeing very much the same thing. So I'll leave it there, because I'm sure my wonderful colleagues have something to say on this as well.
Thank you, Anna. I was going to go to Matt next, but I see Archana, you're off mute. I don't know if you wanted to directly respond or.
I just wanted to piggyback off that to say that, you know, one form of collaboration that we are seeing, which is very interesting and really coalescing at the moment, is the role of multi-stakeholder initiatives. So industry bodies such as the RSPO, Bonsucro, the Responsible Business Alliance, where people are really coming together to experiment with new ways of, you know, reaching workers, new forms of grievance systems where people can pool resources together and perhaps make those resources available to the SMEs by subsidizing the cost of accessing these mechanisms. I think that's a really important development, and a lot of MSIs are currently looking and reviewing their existing systems in order to make sure that they're fit for purpose going into this new sort of, you know, regulatory landscape. I think from a national government's perspective, there is, you know, a very important role to be played, particularly in the ecosystem of remedy. When you think about the fact that the ecosystem of remedy consists of state-based and non-state-based mechanisms, it is so important that there is complementarity between the two. So no private sector actor should really be dispensing justice or attempting to deal with situations of human trafficking, they need to be referred on to law enforcement authorities for proper investigation and dealing with. And, but there needs to be that pathway for this to happen. And that's where the complementarity happens. And a lot of the times it's actors like civil society who help to hold these different elements of the ecosystem of remedy together. And I think, when you start to really engage and look at where liability comes from, for example, in the ethical recruitment piece, you start to really go into labor migration dynamics. You start to go into bilateral agreements. You look at labor standards in those bilateral agreements, and you look at remediation mechanisms for workers who find themselves in a cross-border situation where there has been a violation of rights. Then you start to really unpick a lot of those entrenched issues within the system that contribute to the exploitation of the most vulnerable. And that's how you start to gradually undo. But when you look at the ethical recruitment piece itself, within that, there are so many stakeholders. You've not just got the recruitment agencies, you've got the source country governments, you've got the country of destination governments, you've got, a whole host of actors. Private sector becomes the sort of the linchpin between all of these people, because they're the ones bringing in the labor. And just one more point I'd like to make. Civil society and trade unions play a very, very important role in this landscape. In a very recent effort in Thailand, it was very interesting to hear from NGOs that they no longer wanted to take the naming and shaming approach. They no longer wanted to be adversarial with the private sector, but actually they wanted to find ways in which they could work collaboratively. And they wanted to find ways in which they could be engaged in this whole exercise of improving the ecosystem of remedy for workers through the intervention and support of NGOs, but also through, just being able to be there as the link between workers and their employers, and to be able to foster that social dialogue that needs to happen in order for a lot of these problems to go away. And lastly, I'd just like to mention, a fantastic agreement, an enforceable brand agreement that was arrived at between a group of Dalit women workers in India called the Dindigul Agreement. And that was as a result of, rampant sexual violence and discrimination against women in the garment sector in India. And, it's a wonderful example of how a worker-led effort, a trade union-led effort, can really help to challenge some social norms and patriarchal attitudes and values, and issues like sexual violence and harassment that have been entrenched for decades. And to really help to look at that in partnership with the private sector and with the state in order to arrive at a much better situation for workers. And again, solutions and good practice come in different shapes and packages, and we really need to look further afield for those.
Stephen, can I just respond a little bit to the NGO and private sector collaborative direction? At the end of the day, what we've had for many, many years is a situation where the private sector looks at the NGOs as enemies, that they basically have gone after them, they name and shame, and then the NGOs try to go and say, well, we want to provide some help. I know that there is this desire among the NGOs to move in the direction of having a more positive, supportive approach, but there needs to be a bridge developed between the private sector and the NGOs for that to happen. Because the relationship that existed in the past did not lend itself to the private sector feeling trust that, in fact, the NGOs weren't going to turn after they learned all kinds of information related to this. Now, the relevance of this is that the NGOs understand human rights. They understand how to address survivor-centric type programs. They understand how to deal with things. I've worked with companies that have a large pool of forced labor victims, and they don't know what to do with it. They don't have that expertise. But when kind of offered the opportunity of linking up with the NGOs And in fact, NGOs that have actually worked with this population, they are still very hesitant. They don't want to move in that direction. The point I'm making is that I think ultimately, as we move forward with human rights-ness, both from the corporate side and within the NGO side, a marriage between these two different constituents is very much in the interest of all of us. And I think it has the potential to happen, but we just can't kind of wish it to happen. It requires some bridging, it requires some negotiation, it requires some trust building. And at the end of the day, in the absence of that, it won't happen. But I think it certainly can with the right set of interventions.
Thank you, Matt. I just wanted to reflect back on something that Archana mentioned, and kind of you ended up going full circle, and so I don't think I need to add too much to that. But I just wanted to reinforce the point. Obviously, as you said, grievance mechanisms need to be a multi-stakeholder effort to be effective. And you started to get into the point that grievance mechanisms, remedies, can also be indicators of bigger, more systemic issues that need to be addressed, not just reactively to that exact situation, more proactively at a more systemic level. And so the more that we can think about whether it's grievance mechanisms or other forms of worker voice as an indication of the actual steps that need to be taken to create systemic change to address these bigger issues, I think that will also be hopefully a positive outcome of, and perhaps another unintended consequence of this legislation, that we actually start to think more proactively and less reactively.
Yeah.
Okay, Marina,
Yes.
we don't have any questions yet. And so I just want to remind folks, if you have questions, please add them into the chat. Otherwise, we are here until the bottom of the hour, half past. So we have time to answer questions, but we can certainly continue with the discussion, panel discussion as well.
Thanks. I just wanted to emphasize a few points, and where I think this is all leading. It's just what a beautiful discussion and trajectory. And what's coming to mind now is the fact that we're all in this together, right? Civil society, governments, private sector, trade unions, we're all in this together. And what I'm hopeful about, I see hope as a verb with our shirt sleeves rolled up, right? So what I'm hopeful about is that also from a development perspective, and looking at this, in relation to our technical assistance programming and labor rights programming around the world, is how we're integrating labor rights protections and worker rights engagements within our development programming, right? So like worker rights, labor rights are inherent in many of our development projects, and really working to realize that is something that I'm hopeful about. And also that what I see on the horizon, and many references here today, is that looking at economic growth. And it's not looking at economic growth into the future as growth at any cost, right? We're looking at the costs. And we know that economic growth can actually be utilized as a means to better protect people and the environment when those social and environmental considerations are well integrated. So I'm very hopeful about that as well. And then just to amplify Archana's examples, and there are a growing number of examples when workers are engaged in the workplace, working with trade unions, other organizations, international brands, employers, and the government to make these binding agreements, binding enforceable agreements. That's a step in the rights direction. And then there was also a great point that our administrator, Samantha Power, mentioned yesterday in the launch of a new multilateral, sector initiative, I put a link in the chat. It's called Empower. And you can take a look at that. And so during the launch, Administrator Power also brought out an example in Lesotho, in garment factories where mainly women are employed in this sector, in these factories. And gender-based violence and harassment is a big problem. And so in Lesotho, trade unions and women rights organizations and international brands and the employer came together to address this issue and now have a binding agreement to address gender-based violence and harassment in the workplace. These are the sort of successes that we love to see and support. Thank you.
Thank you, Marina. I think it's a great point with that new USAID initiative. And just as a reminder, organizations like ours, and I'll mention Winrock, and we're here to help. We're here to work with the private sector in collaboration with other stakeholders. We have these projects in countries in Asia, for Winrock and others in other countries, but specifically, in Thailand, we're currently working with the fishing sector, with the sugarcane sector, and soon with the rubber sector, to implement activities that directly respond to the needs identified through this legislation. So there are many activities and initiatives out there that can help companies proactively prepare for compliance with this legislation. And I know you had another NGO example that you want to provide.
Thanks, Stephen, and thanks everybody. Yeah, I think, the wonderful thing about civil society is it tends to spot those grave issues before everybody else and then make enough noise, hopefully, to get some media attention, which then tends to lead to these issues slowly percolating in the boardrooms of the very companies that governments are trying to regulate with the legislation that we're discussing today. And so one of the things that I wanted to mention was that with a lot of the work that we do at Elevate, we, as well as working with the parent companies and the buyers and the suppliers, we also work with NGOs on the ground. And I was speaking with the lead, the CEO of a very grassroots NGO recently. And she said to me, before we started this project, I had no idea that workers could be reimbursed for the money that they had to pay when they were coming into this country. I had no idea that it was possible for this to happen. And, I didn't realize that corporations were even going to go down this route. And she was explaining all of these learnings. And she said, a huge part of the work we do is advocacy. And we advocate to the government. We start locally, and then we have often advocated to the national government. When this project is over, can I take everything that we've learned and what we understand and start to advocate for a change in national policy? Of course, that's exactly the sort of thing that is possible when this sort of collaboration occurs. And I said, absolutely. Roll with it, take it, make as much noise as you need to. That's a fantastic thing to do. And so it just goes to show that when it can seem, and I think this was Marina's point, when it can seem like it's very, very difficult to get a real hold of this, actually, collaboration really is the key. And it's collaboration on an equal standing with partners, whether they are grassroots NGOs, international conglomerates, governments, corporations. It doesn't matter. There needs to be voices that are heard. And in particular, it's the workers' voice that needs to be heard, because through accessing these remedies, through enabling grievance mechanisms and enabling people to have their fees reimbursed for their recruitment that was unethically taken from them, you start to understand how the world actually works. Because if you hear the people,
Anna, I have to jump in here, because there's one thing I feel really strongly about is the concept of remedy is so much more beyond this idea of reimbursement of fees. For me, one of the biggest learnings of the example you've just given is the fact that that is the beginning. And there are so many more opportunities, people, because we have now started chipping away at that block. So I really appreciate the example you shared. And something I'd like to add is, as a result of the WRO on Top Glove, for example, and various other companies, we've just finished a study looking at the impact on access to remedy and remediation for workers of the WROs. What's been interesting, looking at 9 countries and 8 sectors where these WROs have been imposed, is the fact that the only scenario in which a company not only reimbursed recruitment fees, but also set up a sinking fund in order to cover any potential claims for forced labor that workers might have to make or might wish to make at a later date, was Top Glove. 3 years ago, this would have been inconceivable. But the fact that there was reimbursement and there was a thought process that involved thinking about making individuals whole who had been in the experience of forced labor is already such a big step in the right direction. And I think, as we pat ourselves on the back for the fact that these reimbursements are made, we must not forget that it does not represent the entirety of the experience of workers in forced labor or in other situations like these. And while we are off on a good start, there is still so much more to be done.
I completely agree.
Obviously
There's so much more to be done. Absolutely.
And of course, the very concept of reimbursement is reactive in and of itself, and we need systems that that move away from this idea that workers should be paying any upfront costs. That there's an economic model that's set up right now where employers are essentially deriving revenue from the recruitment and migration process. And when that's the initial driver of that economic system, it's going to continue to exist the way that it is. And that's a big ship to turn, but hopefully, legislation like this will start to create more situations where, workers are not forced to pay those fees up front. So, okay. So, we just have a few minutes left. I'm still not seeing, I'm still not seeing any questions in the chat. So maybe I'll just kind of open it up again to the panel and any closing comments that you want to make. We have about 5-6 minutes left.
If
Maria,
I may,
yeah,
I
go
wanted
ahead.
to raise a point that I intended to raise, but we haven't. And I believe it will have, I know it's having impacts in Asia. And that's the passage of the Uyghur Forced Labor Protection Act in the United States. And what's interesting and new about this act, which does, I would put it in the group of import, I'll just use the term import bans, okay? And but these are the withhold release orders that our China mentioned a few times, that the U.S. Customs and Border and Patrol Agency administers. But one interesting thing I want to point out for people about this new Uyghur Forced Labor Protection Act is that it creates what we call, I'm also a lawyer, it creates what we call a rebuttable presumption. So in the law, what that means is that it presumes that goods produced or sourced in the Xinjiang region of China are produced with forced labor. And so the rebuttable presumption is that if you are a company sourcing from this region, that you have to be able to demonstrate with clear and convincing evidence that the items were made without forced labor. So this is a new development in this space, and it's going to require even greater supply chain mapping and tracing from this region, since the risks are so high. Just putting that out there. Thank you.
Yeah, I just wanted to just a couple of ending remarks, and by basically saying this is an exciting time, and it's an exciting time because what we have is a situation where an entire new sector is being brought into the fight. And what I love about working with the private sector is that once they recognize that there is an issue that has to be addressed, they do it very quickly because they have to, because of the potential reputational risk associated with this. And so what you have now are organizations that are much closer to kind of the labor force that have a mandate to do the right thing related to human trafficking, modern slavery, child labor, human rights, and so forth. And they're now gearing up in order for that to be very much a part of their sustained business. And as a result of that, if you get a corporation that has 500,000 employees in multiple countries around the world, then you're affecting, if at the top of the organization says this is what needs to happen, all the way down to the lowest level. And I think that that is going to have major positive impact on significantly increasing the number of people who are supported and helped over time to be out of these exploitative situations.
I think my closing comments will very much be that, you know, I've been in this space for about 16 years, done everything from write the law for governments to represent workers in cases. And I think I have a lot of cause for optimism today, more than I did 5 years ago. And I think there are so many opportunities right now to really be a lot more proactive in the way we approach these systemic issues, and to really peel back the layers and look at how we deal with deeply entrenched issues and not apply a band-aid to it. We do need to move beyond just compliance. We need to form as many allies along the way as we can. And, you know, all of these allies, whether they're in government, whether they're in civil society or at the trade union level, each have a role to play and something to contribute to the movement that is fairly unique to them. And I think as we pull away, it appears that we all have different agendas and are pulling in different directions, but actually everybody's driving towards economic prosperity. And I think, you know, whether you're a government, whether you're a worker who's left home and who's traveled abroad to work, or whether you're the private sector who's just trying to maximize shareholder value, the point is economic prosperity drives a lot of this. But it must never come at the cost of humanity or at the cost of the planet. And I think as we continue to be guided by, you know, the laws and the regulations and doing the right thing because you're required to do so, we must always remember why we're doing it and the common factor that we all share, which is our humanity. I'll leave it there. Thank you.
Anna, did you want to close with anything?
I think they're extremely powerful words from our three speakers, and it's very important that we do collaborate on this. And I think the idea of creating allies rather than enemies on the way is extremely important. And a lot of the time, just as we close, think about if the message that someone is telling you is not necessarily what you want to hear, it's not necessarily the person that's giving you that message that is wrong. It may just be that you're speaking in a slightly different way. And we see this a lot where civil society and corporates may not be speaking the same language, even though they're trying to get the same outcomes. So it is about, there's patience needed in terms of translating those different ways of approaching certain issues, but that we are, as was just mentioned, going in the same direction.
Thank you.
We're
Anna.
all in
Yes.
this together.
Yeah, it's certainly a hopeful message, but I think we all know we have a ways to go as well. And we also know that these are very serious issues that are affecting people in very negative ways. And we know that the issue, according to the latest statistics, is growing in regards to major human rights abuses. So there's hope, but at the same time, there's an urgency to the challenge that exists currently. So I want to thank our wonderful panel for the insights that you provided through this session. And I know there's more to come, so I'll turn it back over to the moderator.
Thank you so much.
Thank you.
Thank you.